Ray, good morning.
Good morning.
Well, we are here because you and your firm, Chandler and Jennings, you had an involvement in a historical case. It was almost a case where it was kind of unearthed, per se, and it goes back to the 40s with something that's very well known in South Carolina called the George Stinney Jr. case.
Yes.
I have 1,000,001 questions about that, Ray, but I want to know, first and foremost, what made you decide to be involved in this case?
This case was brought to me, or brought to my attention, and I regret to tell you this, that I had practiced in Clarendon County for many, many years and had just heard the name, but had not looked into the details. I feel somewhat myopic about that, that had not done it. But the case was brought to me by another lawyer who was very, very interested in getting it done. And we had then talked to a number of interested lawyers, a number of interested organizations, some civil rights organizations, some foundations that were interested in revisiting the George Jr. Stinney case.
Right.
It has been revisited numerous times since his death in 1947. He was 14 years old, the youngest person to be executed in the United States, electrocuted.
71 years ago.
Yeah.
Right.
And he was so tiny that they had to put books up under him in the electric chair to get the voltage to go through it.
Yeah.
It's an incredible thing. It's 4'7", 96 pounds. I took an interest in it because he was tried and convicted in the courtroom where I have made my living since 1979. And it was an horrendous process. 80 days from the time he was charged, he was dead. 80 days.
Wow.
From the time he was charged, he was dead. No testimony from the defense. No witnesses put up. A 10-minute verdict after a one-morning trial. No appeal. And so once I saw the facts and realized that there were other cases in South Carolina during this period of time, 1943 to 1949, that African American men were charged with raping a white woman, which at that point was just the flashpoint for the anger, hatred that welled up over race. I mean, it was just awful. George Stinney's death and execution was the most dysfunctional thing that one could ever even think would happen. I mean, it's absolutely beyond comprehension. My point was that it should have been beyond comprehension in 1947. I mean, it should have been. And it wasn't. It wasn't.
That's a great point. I have a question for you on
Sure.
that. How hard, with the case being over 70 years old, and we talked about facts, how hard is it for you to unearth a lot of these facts?
It's impossible. When we took it, started with it, it was dead on arrival.
Wow.
It was moribund, no matter who had looked at it. And I want you to know this. Going back to the 1800s, there are files in the Clarendon County Courthouse repository of criminal cases, almost all of them, except George Stinney's. It's missing. It ain't there. Okay. And so you go back to the state archives, and when you go back to the state archives, you find that everybody and his brother's been there looking at it. Going back through that does you some good, okay? But the challenge is what legal standard on which to bring it. Because in my mind, there is no such thing after 70 years as newly discovered evidence.
That's right, yeah.
There's not going to be anything.
Or new witnesses.
Yeah, new witnesses. And then if there is, you've got the passage of time that precludes any legal action under one of the appellate rules. And this is what Blair Jennings said when he and I were consulting, on it. Blair said, the good news is that we know that there are things that weren't presented, right? The bad news is, the legal standard is, if you knew or should have known at the time and did not present it, you're precluded from arguing it later. And that may be a story for another time, but there was a political reason that the lawyer that was appointed to Steny, who was a young lawyer with political aspirations, was appointed.
Well, he wanted to probably make an example at that time or make a name for himself.
Well, he wanted to make a name for himself politically, but not as the lawyer for George Steny.
Understood.
Right? That's the difference in Chandler and Jennings and that lawyer. We aren't in politics. And if we have to take a case, we're going to take it, and it's going to be 150%. Politics be damned.
Right. Just painting the picture, this was 1944, Clarendon County. 47, Clarendon County. There was like a railroad track that kind of separated the people. The whites lived on one side, and some of the blacks lived on one side. And these two young girls, they went picking flowers.
Looking for maypops.
Looking for maypops. George was walking, I believe, with his sister.
George and his sister, after school, their job was to take the cow out to graze. A 14-year-old kid out there with his younger sister, probably bored to death, at wanting to do that. And so I'll paint the picture for you. These two girls were, I think, 11 and 8. The older girl was named Benneker, and the younger girl's last name was Timms. And as the account was given, and these are newspaper accounts, okay, not testimonial accounts, was that Ms. Benneker, the Benneker girl, asked the two Stenys if they knew where there were maypops. And apparently we're told that there may have been some, there could have been some down this road. It was a country road. And it was a distance from maybe an eighth of a mile, a quarter of a mile from the community. The girls left, and they didn't return home for dinner. And so there was, within hours, less than hours, there was search parties organized. People were looking for them. And African American people were in the search party. George Steny's daddy was in the search party. And that night, they searched into the night and did not find these children. In course of the search, investigation, people were asking questions, and George's Steny's sister had told the mama, and the mama had told the daddy that George and his sister had seen the two girls that afternoon, and they left with the bicycle. So now I've got an 11-year-old, an 8-year-old, and a bicycle, okay? And I've got a 4'7", 96-pound, diminutive, frail young man.
That's very small.
Okay, very small. Very small. Now you think about that in terms of what the average 11-year-old weighed, and I did that research, by the way. Actually, Lauren Felder of Chandler and Jennings did that research because she's OCD. She did the research, and she comes to me and she says, Ray, look at the Department of Agriculture statistics of what the average woman, young woman, child at 11 is, and it's 78 to 82 pounds. Well, this child was probably just an inch shorter or the same height as George Steny and weighed 12 or 13 pounds less. And then there was an 8-year-old. So now you've got the challenge for this diminutive, tiny George Steny Jr. at 14 to overcome and murder two women leave the cow.
Ditch his sister.
Yeah, ditch his sister, overcome and murder 2 women, right? Then drag them or carry them both to this ditch and the bicycle. Just didn't happen. Matt Burgess found the autopsy report at the archives, and the autopsy report in and of itself was somewhat vanilla, right? But it's got a great story behind it, okay?
Yep.
And this is the great story. The autopsy was done by a country doctor who was a legend in Clarendon County, A.C. Bazard, okay? And Dr. Bazard had come to Manning to take over a doctor's practice. And it was Dr. Bazard and his nurse, and he subsequently married his nurse. Okay. And they were husband and wife and practiced medicine together. So Dr. Bazard obviously was one of those that took the bag into your house, right? Delivered babies,
Came with a medical bag. He's the
black
guy.
babies, white babies. You know, he was Dr. Bazard, right? And so he did the autopsy himself. Mm-hmm. And another doctor, whose name eludes me, from Sumter, signed off on it because both of them had to sign it. Okay?
Was that law or?
Yeah, they had to sign it. However, in the trial, apparently Dr. Bazard had a cold. And the other doctor who didn't perform the autopsy testified.
Not the one that signed off.
Yeah, the one that signed off but had not done the autopsy.
He was there.
Correct.
Got it.
So remember that this was the murder weapon. Forget there was no motive in this case, other than George Denny Jr. was just a mean little son of a gun.
Wow.
Right? Does that make sense? So,
wow.
So a mean little 14-year-old son of a gun kills 2 complete strangers who happen to be female. So the theory was it was sexually related, motivated. Okay? Well, the autopsy did not show that there was any sexual molestation at all. Okay? Of the 11-year-old, obviously we would not think of the 8-year-old.
Yeah.
The autopsy report showed very few scratches or abrasions on the children. The autopsy report showed no evidence that those bodies had been dragged anyway, because what you would have seen then was bruising or something on the backs
debris
of
or anything on their bodies,
their
right?
legs. Okay, and there were no ligature marks on their arms for being tied or bruising from being dragged, which you would normally see when the blood, had stopped. You might see that. This guy who called in, there was no blood at the scene. When they found the 2 kids, there was little or no blood around the scene, which meant that the thing had happened somewhere else. You get to the autopsy report, and this is when Blair and I look at it. And I called a forensic pathologist who was Canadian, had retired in North Carolina, and had testified for me in a case, a baby death case, maybe 7 or 8 years before. His name was Dr. Peter Stevens. And I sent Pete the autopsy report and the facts surrounding it, okay? And he called me. He's got that Canadian, British, type voice. He calls me about 3 days later, and he said, "Ray, these 2 children were beaten to death." And I said, "No joke, Doc. What else can you tell me?" He said, "It wasn't a railroad spike." I said, "So what do you think did it?" And he said, "Well, if you look at Dr. Bazard's report, he tells you it wasn't a railroad spike. He said the indentions were rounded like a hammer." So these children, we believe, Dr. Stevens believes, were killed with a ball peen hammer, with the rounded part of the ball peen hammer. Okay? He says that because A, the indentions would be very similar. They're under the size of a quarter. Okay? 2, the hammer handle would give you the leverage that you needed.
To be able to swing it.
To inflict that. And so if you say, well, George Stinney used a 4 to 5 pound railroad spike, okay? Railroad spike would be about 8 or 9 inches long. It's heavy and it's square, right? So Stinney would have his little hand around the railroad spike at some point, right? And now with his height, how is he going to get to the top of the head of this woman who was about his height to crash her skull? And what the heck was the second person doing while he was doing that 4 times? They'd be running. They'd be running. And could he run them down and without any ligature or anything else then get to the top of her head? It's ridiculous. So the bicycle that was found had been broken. Okay, we think something with the tire, with the wheel. We believe these girls got picked up in a car. Okay, we believe the individual who picked them up took them back to his house and was, quote, working on the bicycle, right? Girls were distracted. He came up behind them with the ball peen hammer and murdered both of them.
And he probably knew them.
And then he was able to put the girls and the bike in the car trunk and take them somewhere and carry them, because he was a big guy, right? And carry them, he wasn't 96 pounds, and carry them and place them, and then carry the bike. George and his brother were arrested, taken out that next afternoon, late after the girls were found that morning, early that morning. George's mother, father, and sisters left Alderman Lumber Company and went to Sumter area, Pinewood, never returned. So they were not available at the trial. The brother was later released, and 2 policemen rode him back out toward Alcaloo, stopped at a stop sign, and threw him out of the car on the ground. At which point he walked away from Alcaloo, found somebody to put him up for the night, and within a month had joined the Army and never returned. How do you couch this case? Okay, it wasn't a Fourth Amendment case because it wasn't a search, right? But it's clearly a Fifth Amendment case, right? And it was clearly a Sixth Amendment case, okay? Because the entire method of the trial smelled, all right? So it hit me that, and this is one of the experts that Chandler and Jennings uses, okay? This is a Chandler and Jennings expert, and she's my buddy. Her name is Dr. Amanda Salas. Guess where she was from? Manning, South Carolina. She is an adolescent, child, and adult psychiatrist qualified in all 3 forensically. And do you know what her qualification paper for her child psychology was? George Stinney.
So she was versed before she got the call.
When I called her and I said, I'm calling you to help me out in a case, and she said, what's the case? And I said, George Stinney. Her words were, oh my God. We had a third part of the puzzle. Third part of the puzzle, remember, was how to get into court.
Right.
So Lauren Felder called a former professor of hers, Miller Shealy, who's a criminal law professor at Charleston School of Law. And then Steve McKenzie followed up, and I credit Steve completely with getting Miller into the case and prepped up for the case, etc. But there's an old common law writ, and South Carolina still uses the common law. So the old common law writ in England was a writ called coram nobis. And coram nobis, the Latin term, there's an era before us. It would be one of those that the court could say yes or no. So we had Miller, now, right? We had Dr. Peterson, and we had Amanda Salas, right? So we had all the bases covered, but we wanted to show the unjustness of it. So I went up to New York and took the deposition of George's older brother. And I took the video deposition of this gentleman who had had a stroke. I had to pick him up at his house. I had to drive him in a car, to the place, get him upstairs, sit him down, feed him, and then get him to do the deposition. Then we paid the way for his sister, who was in good health, the younger sister.
She was 77, I think, at the time.
Come to court, and she was a good 77.
Mm-hmm.
Come to court in South Carolina, where we tried it in Sumter.
Mm-hmm.
Now, here's the picture now. This is how it all comes together. I've got an African-American prosecutor in Ernest Finney, Jr., whose father was my dear friend, was the first African-American circuit judge. I tried his first criminal case in Manning. I was the defense lawyer, and he was the first African-American on the Supreme Court and Chief Justice of the Supreme Court. He was the prosecutor, okay? And these white guys were the defense. Does that make sense?
That's a turn of events there.
And now I got a female judge, all right? And so I'm liking all of this. I'm liking all of this. And then from out of the woodwork, after we'd spent all of this money and all of this time, here comes CNN, here comes 2020, here comes NBC, here comes Fox News, wanting every piece of us, right? Wanting every piece of us. And they were wonderful, but I had told the Stinney family that we would not bring a lawsuit. Chandler and Jennings would not do this for money. You can't do this for money, all right? You do this because it's right. It cries out.
Do you feel like people, especially like some young black youth, do they get a fair trial today?
The difference in trials today and trials in the 40s or 50s is not apples and apples. In South Carolina today, there is a significant amount of effort that is put on getting it right. The inequity in our system nationally, I don't think has to do with race as a whole. I think it has to do with money. I think you get a better trial in some cases if you can pay for it. The bias in the George Stinney case was a racial bias,
right?
But it was a cultural bias then. I'm not excusing that, but that's how it was.
That's how it was back then.
Right, how it was. If you applied that bias to 2018, that would be horrific. That doesn't exist. That doesn't exist. Do law enforcement people make mistakes? Yes. Do they lie? Yes. Okay. Do they step over the line? Yes. I see it every day. Okay. But they do it notwithstanding the racial. I see them do it to Hispanics on I-95. I see them do it to other things. What's it about? It's about laziness. It's about the abuse of authority, right? It's about the position. And just in every walk of life, I know you see it, the wrong people get in the wrong jobs. This is fixed because people, whether they're of color or not, people are human beings. And tragedies such as the George Stinney case strikes your heart.
Absolutely.
Both of our bloods are red. Our hearts work the same. And our devotion to doing the right thing is similar. And so George Stinney gets fixed because the lawyers at Chandler and Jennings decide that it had to be. You ask me why I did this? Because it had to be, right? And I will tell you that if somebody that God had not blessed with money, and that God had not blessed with the talents He has given me that I do not deserve, and not the ability to associate with people of the character of Blair Jennings and Lauren Felder, it wouldn't happen.
And I will say this, and we'll end it here. This had to happen because it had to be done.
Yes.
And I want to say thank you for fixing it. Thank you for going back in time and doing what was right in history.
Thank you, sir.
Thank you.